Hello, everyone, and welcome to On Civil Law. And for today's story, we are covering the ongoing proceedings in New York State Court relating to the sentencing of Donald Trump for the many, many felonies, that he supposedly committed relating to campaign finance, bookkeeping errors that were. The whole trial is very, very weird, as anyone who's been covering this knows. And they seem very desperate to impose sentence despite operative law that seems to be suggesting that they shouldn't do this, to my mind. So I'm having a very hard time squaring this, what's happening with legal principles that I understand. And I like to understand things, and I don't understand things, except that they seem desperate to bend the rules, is the only sort of conclusion I can come to right now, because no other explanation makes sense, so that they can impose sentence on Trump. So we begin with the trial level court on Friday, who denied a delay. And then today, an appeals judge also denied that same delay, which seems to me to be questionable on legal grounds. So we'll begin with the trial judge, Merchant, from Friday, who denied the attempt to delay the sentencing. The legal basis, by the way, for those of you who are curious, is immunity. Immunity is an issue that is typically appealable while a case is ongoing. So as we've discussed before, appeals while a case is proceeding are typically disfavored. And you can't appeal until a case is finalized in most situations. But an immunity issue is an issue where you typically can appeal while a case is ongoing, because an immunity is different than a defense. A defense is, basically, I didn't do it. An immunity is, you can't even charge me. So I didn't do it, or I'm not legally responsible, would be an example of a defense. You can't even charge me is an example of an immunity. And because the very prosecution, the very court case, is itself the thing that the immunity prevents, right? The whole point is the immunity prevents you from being prosecuted. The very fact the prosecution allows it to go forward would be in a violation of the immunity, which means that you have to have the right to appeal to prevent the very thing that the immunity is supposed to prevent in the first place. So hopefully that makes sense. And he should have the right to appeal, but they're not giving him the right to appeal, even before sentencing, although he should have it, which seems really odd to me on legal levels. President Donald Trump remains on track to be sentenced this week in his hush money case after a judge on Monday denied his request to halt proceedings while the appeal court issued a ruling that upheld the historic verdict. Well, strictly speaking, while he appeals the ruling that upheld the verdict, the Manhattan judge, Juan Merchant, ordered sentencing to proceed as scheduled on Friday. That'd be this Friday. So coming up pretty fast, a little more than a week before Trump's inauguration. The judge rejected a push by Trump's lawyers to postpone it indefinitely while they asked the state appeal court to reverse the decision last week that let the conviction stand, or more to the point, challenge the immunity decision. Because certain acts, certain evidence was brought into trial that arguably Trump has immunity for because they occurred while he was president. So there's a whole immunity issue, and I don't know how to even begin to untangle that, because it's a huge legal issue that needs, a detailed legal analysis. And they're like, well, we don't really care. We don't really care. We're not going to do the detailed legal analysis. So that's really weird. Trump, of course, is on course to be the first president to take office convicted of a crime. Can still ask the appeals court to delay sentencing or seek another court to intervene. His lawyers have previously suggested taking the case all the way to the U.S. Supreme Court, which, I would be filing in federal court for some sort of writ right about now, would be what I'd be filing for. I guess a writ of prohibition would be my first thought. Would be what I'd be filing for in federal court on an emergency basis, on the basis that they can't do this. So that would be my idea. Trump's lawyers have told the trial judge Merchant that if the sentencing happens, he'll appear by video rather than person. The judge had given that option, acceding to the demands of the presidential transition process. Last Friday, Merchant denied Trump's bid to throw out his conviction and dismiss the case because of his impending bid to return to the White House, but signaled he's not likely to sentence him to any punishment for conviction for the 34 felony counts. It's worthy of note here that these are Class E felonies, which is the lowest degree of felony in New York. And I believe that a prison term isn't even indicated under these circumstances under relevant state law because of how they are grouped and stuff like that. So the fact that there's no penalty, or the fact there's no prison sentence, would seem to be suggested by the guidelines. Trump wrote on Truth Social platform after Merchant ruled it would be the end of the presidency as we know it, if it's allowed to stand. Trump's lawyers, who also challenged Merchant's prior refusal to toss the case on presidential immunity grounds, filed paperwork in the appellate division, which at least one justice there too has so far denied. So the emergency appeal judge on the Court of Appeals said no. And now I suppose they're going to try to have an emergency hearing with a 3-judge panel by Friday. Good luck. Today, Trump's legal team moved to stop the unlawful sentencing in the Manhattan DA witch hunt, the Trump spokesperson said. The Supreme Court, and by the way, here, when they say Supreme Court, I'm not even sure what they mean, to be honest. I'm not sure which Supreme Court they mean, because New York refers to its trial courts as Supreme Court. So when they say the Supreme Court's historic decision on immunity, I'm not sure whether they mean the U.S. Supreme Court's decision on immunity or whether they mean the New York trial court's decision on immunity, because New York insists on calling its trial courts Supreme Court. So I'm not sure which Supreme Court they mean there. That's just some nice ambiguity. That's just funny. The state constitution of New York and other legal precedent mandate this meritless hoax be immediately dismissed. Trump's lawyers did not immediately ask the appeal court to halt sentencing. Well, they did, and it was denied. We'll discuss. In a separate filing with Merchant, they argued the appeal should be automatically paused, and then said that if he didn't, he should do it himself. An idea he rejected. An idea he rejected, incidentally, with no legal analysis. He just simply said the cases that were cited by Trump were factually distinguishable and inopposite without any real analysis. I don't know why they're factually distinguishable or inopposite. He didn't tell me. The judge in their decision just simply said these cases don't apply. Why don't they apply? I don't know. He didn't say. They just don't apply for reasons. Orange Man bad, maybe? I don't know, but they didn't say. It's very annoying from a legal perspective, because it's like, well, tell me why I'm wrong, and they won't tell me. They literally won't tell me. Manhattan prosecutors had urged Merchant to proceed with sentencing as scheduled, given the strong public interest in prompt prosecution and finality of criminal proceedings. Prosecutors blamed Trump for pushing the sentencing to the brink of the second term by repeatedly seeking to postpone his sentencing, originally scheduled for July. He should not now be heard to complain of the harm from the delays he caused, they wrote in the court filing. Well, it's not necessarily delays he caused. He's fighting legal issues, and those legal issues have merit to them, it seems to me. So I'm not sure. It's not simply delay for the sake of delay, or it doesn't seem to me. There seems to be a viable legal issue here to be had. Any delay in sentencing could, of course, run off the clock on the case, but that's an operation of law, right? So that's a collateral consequence. Right? Because I'm a rule kind of based guy. I'm a rule based guy, and I like to look at rules and what rules we have. And it's like, look, this sentencing, there's a valid challenge. The problem, of course, well, the operative legal issue, let's say that the operative legal issue is between the time of the conviction and now. The U.S. Supreme Court issued its decision relating to immunity of the president. Right? And so that's a change in the operative law. It's a change in the operative law of a live case. So, you have to go back and try to figure out whether or not you made a mistake. Now, it's not necessarily your fault, necessarily, because the operative law has changed out from under you. So it doesn't necessarily mean the judge necessarily erred, or I suppose it depends on your point of view of such things. But it's not necessarily like the judge was openly defiant of something. The judge was maybe trying to make their best guess as to what they thought the law is, which, that's what judges sometimes have to do. They have to make a decision as to what they think the law is. And the judge was trying to make their best guess. Okay, fair enough. But the Supreme Court said you guessed wrong, or might have guessed wrong. The law has changed. Okay, so fair enough. Now I need to go back and I need to figure out whether or not I made a mistake in view of the change of the law. But I'm not really doing that. That's the problem. It's like, I'm just not really applying this. I'm like, there's no immunity issues. We can go forward. It's like, are you sure? I'm pretty sure. It's like, okay, I'd like to appeal. It's an immunity issue. I should have the ability to appeal. You don't get the right to appeal. Why not? You don't get the right to appeal because this is different. Different in what way? It's different factually. Different factually how? There's just like, the whole thing just doesn't really work. The whole thing is just sort of vague. The Justice Department's Office of Legal Counsel, which provides legal advice and guidance to federal agencies, has maintained a sitting president is immune from criminal proceeding. If sentencing didn't happen, then he may have to wait until he leaves office, which maybe that is the answer, but that is just an operation of how different laws interact with each other at that point. So maybe, but it doesn't necessarily mean you can just rush this proceeding because it would be convenient. The clock sometimes runs out. That's how that sometimes works. If sentencing proceeds as scheduled, Trump's lawyers will argue he'll be appealing the verdict while in office and will be forced to deal with criminal proceedings for years to come. They raised the scenario which, if Trump wins, he could then be subject to a criminal trial while in office. Which, fair enough. It would surprise me if he doesn't eventually win on something. Right? It would surprise me if he doesn't eventually win. And someone somewhere, and it might be the U.S. Supreme Court, is going to vacate this for further proceedings. And then just like undo the whole thing. So it's going to become very, very ugly. It's going to become very, very ugly. Which maybe is exactly what they're trying to do. Maybe they're just trying to make it ugly. In upholding the verdict and rejecting the bid for dismissal, Merchant wrote that the interest of justice would only be served by bringing finality to this matter through sentencing. He said giving Trump what's known as an unconditional discharge, closing the case without jail time, fine, or probation, appears to be the most viable solution. Okay. I guess. Trump's lawyers were unmoved, arguing this meritless case was fostered by numerous legal errors, including rulings by Merchant they say flew in the face of the U.S. Supreme Court's decision that granted immunity. Maybe. I mean, there's a legal issue there, not for the least of reasons that the U.S. Supreme Court just invented this just now, basically. So we don't necessarily know what the legal answers are because it's kind of a new area of law. The Supreme Court the Supreme Court at least said this is a new thing. And so no one's really 100% sure what the boundaries of this thing are yet because, it's kind of a new area of law. And so we have to go figure it out. But, that's part of the reason that we have appeals, and we should have appeals and reviews and everything else to make sure we get it right. The court's non-binding preview of its current thinking regarding hypothetical sentencing does not mitigate the bedrock federal constitutional violations, defense lawyers wrote. I mean, the judge says this is what my intentions are, but until it happens, it doesn't exist, right? The judge saying, I'm looking at an unconditional discharge until he actually imposes a sentence. It's just musings that don't really count. Trump will have an opportunity to speak at sentencing, which fair enough. He can only appeal the verdict after sentence, which, typically would be true. Typically, you can only appeal a verdict after sentencing. Typically, you can't appeal in the middle of a case, but it's an immunity issue. So you should be able to, but for some reason you can't here. Now, the charges involve the scheme to hide a hush money payment to Stormy Daniels, which then centered on reimbursement and payment. The whole thing is like legally weird. The whole case is legally weird because it's a misdemeanor that they've somehow tried to turn into a felony, and they can't even agree on the basis of the felony, and they didn't require the jury to agree on the basis of the felony. So it's a bookkeeping problem, right? It's lying on the books. It's forgery. It's faking the books, which it's a misdemeanor unto itself, right? The mere act of corrupting the books is a misdemeanor. Now, if you do it for a further purpose, it might be a different kind of crime, right? So if you do it for the purpose of a fraud or do it for the purpose of whatever, then that might be a felony. But the mere fact of corrupting the books is a misdemeanor. And the statute of limitations ran out on that long ago. So they had to somehow turn it into a felony. Why is it a felony? A campaign finance violation, they said. A campaign finance violation, incidentally, the federal government refused to prosecute. They couldn't find enough evidence for it. A federal campaign finance violation. And then there were like 3 different theories of the crime, and they didn't even require the jury to agree on which theory of the crime. So the whole thing is like legally sketchy to me. The whole thing is like legally sketchy. It is really trying to squeeze the statute until it squeals like a pig, I guess. All right, and so then coming to today, the appeals court has rejected Trump's latest attempt to get the Friday hush money sentencing called off. And apparently it's just simply a 1-page decision, which is also super exciting. The appeals court judge on Tuesday rejected President-elect Donald Trump's last-ditch bid to halt the sentencing. In the 1-page decision, Associate Justice Ellen Mesmer wrote that Trump's effort was denied. Well, that's a robust legal analysis, right? That's a robust legal analysis. Oh, this is not silly uncivil. I know you thought you understood when interlocutory appeals could happen and when they can't happen. I know you thought you understood that, but you're just a silly uncivil. You don't really understand it. You know, here's what the law is, and here's what the law has been all this time. Let me explain it to you. No, not so much. What we've got is a 1-page decision that simply says denied. This is not helping me as a legal educator, because how am I supposed to explain it? How am I supposed to even explain the disagreement? Because what am I disagreeing with? I'm just disagreeing with a denied stamp. How am I supposed to argue with a denied stamp? How am I supposed to explain a denied stamp? This is not helpful to me. Trump had asked the New York Court of Appeals, known as the Appellate Division, First Department, because it's Manhattan, to toss out the jury's May verdict. Well, strictly speaking, again, not necessarily toss out the verdict. Again, the issue is immunity, which is a little bit more specific than just tossing out the verdict. It's not quite the same thing. Which found Trump guilty of 34 counts of falsifying business documents, which should be a misdemeanor, but are somehow magically a felony because of reasons. In the appeal, he argued he's protected by presidential immunity, argues that the trial judge, Justice Juan Merchant, and someone has to at some point explain to me who gets to be called judge and who gets to be called justice within the New York system. How does that work? Is every judge just called justice? Is that how they do it in New York? I honestly don't know. It's just odd to me that the trial judge's title is justice. I don't get it. It's just every judge called justice in New York? I don't know. But they call him justice for some reason. Trump also sought to have the sentencing canceled while he appealed. The appellate judge appeared skeptical of the arguments presented earlier on Tuesday by Trump's lawyers. In particular, Gessmer questioned the argument that presidential immunity should apply to president-elect. Well, that part I'm skeptical of too. That part I'm skeptical of too. I don't think there should be an immunity for the president-elect. That sounds dumb. But that's not what I'm trying to do. That's not what I'm trying to do. right? So I thought that argument by Trump was dumb. I thought it was dumb. It's like he should have immunity because he's president-elect. And that's like the same thing as being president. No, it's not. That's incredibly dumb. It's like you're either president or you're not. It's no halfways about this thing. So that real argument's really dumb. He should have immunity because he's president-elect. No. But he should have immunity for things he did while he was in office because the U.S. Supreme Court said so. It's like, oh yeah, that makes a lot more sense. So, and then there's a whole question of, did we use certain evidence that we weren't allowed? Was certain things allowed to be brought in? And there's a whole evidentiary question that should be reviewed, but we're not going to review it now. Can he use the argument now when he's been confirmed, not just sworn in? No. I mean, for me, this is a no. That doesn't count, right? You're either present or you're not. So until 11:59 a.m. on the 20th, right? Until 11:59 a.m. on the 20th, he is not the president of the United States. So that argument doesn't work for me. But what does work for me is that he has immunity from his prior service as president. That works for me. Merchant has indicated he won't sentence the president-elect to prison, which I'm not sure was ever really an option, strictly speaking, anyway, but okay. Trump has asked the appeal court to hear his argument on tossing the verdict on January 27th, which of course is too late. Can he do a secret swearing in and January 20th only be pro forma? No, his term begins on January 20th at noon. It's in the Constitution. That's when his term begins. And strictly speaking, he doesn't need to be sworn in. His term begins at noon. So, yeah, no. Yeah, he becomes president at noon on the 20th. Yeah. Until then, he's not president. Until 11:59 a.m. on the 20th, Joe Biden is president. Barring some sort of cataclysm between now and then. So, Article 1, Section 8 requires oath of office. In order to execute the office of president, it does, yes. In order to execute the office of president, it does. But he's still the president. He just can't execute it until he takes the oath of office. Right? It would be the same thing, incidentally, by the way. Like, it's one of these, like, technically correct is the best kind of correct things. Like, it would be the same thing, like, if the president died. Right? It's like, technically, whoever's next in line becomes president the moment the president dies. Right? It's just that they can't execute the office until they actually take the oath. But yeah, it's one of those, like, technically, it's one of those things, like, it's kind of in the same way, or at least it's comparable to the same way that, like, the moment the queen died, the king became king. Right? The very moment the queen died, the king became king. And then later there was, a ceremony and all the rest of it. But, it's kind of similar, comparable, right? So the very moment the president stops being president, someone's president. It's just they can't execute on it until they take the oath of office. So it's one of those very sort of technically things that, yeah. There is no requirement as to, there is a requirement as to when or where. There is no requirement as to where. That's true. When is fine. Like, when is sort of dictated by law. Johnson was sworn in on a plane. He was sworn in on a plane. That counted. Yeah, so there's no particular requirement as to where. There is a requirement as to when. It doesn't necessarily require witnesses. That's true. Although you'd have to have implicitly at least one witness because you have to have the person that's swearing you in. But yeah. Can Trump's attorneys do an emergency Supreme Court on this? They could try. They could try. I mean, my first thought would be filing in federal district court. That's my first thought on an emergency writ, probably a writ of prohibition would be my first thought. Would be my filing in some district court somewhere. You can't file in the first instance in the Supreme Court. You can't file in the Supreme Court originally. So you either have to do like one of two things. Either somehow you have to appeal this to the U.S. Supreme Court, which I'm not sure you can do, because the U.S. Supreme Court only hears from state cases, like cases that are final as of state law and have gone through every state level proceeding. So I don't think you can jack this and take it to the U.S. Supreme Court. I don't think you can do that. So your only other solution here is to file in federal court, which I think you could do. You can file in federal court for a writ of prohibition in district court and then try to get the writ granted. And presumably, if they denied it, then you could file for an emergency injunction in the U.S. Supreme Court. So you could try that. So that would be the mechanism for that. What if he refuses to comply and just doesn't show? Well, if he doesn't show, presumably they will sentence him in absentia. So I'm not sure it will matter. It's like, we gave you notice. We gave you notice, and presumably they'll just sentence him in his absence. So I'm not sure that gets you anywhere. I mean, other than just being defiant for the sake of defiance, which, you know, also technically by refusing to show up, the judge could hold you in contempt for failure to show, which would give the judge another basis to punish you for contempt. So, yeah. So that's sort of the standard there. $6, €6. These for €6 says thoughts on Nick's latest Schizo Locals post regarding Aaron. I haven't seen the post. I'll read the rest of your comment and then I'll comment. It includes metaphors involving vanilla cream and is akin to the ramblings of a lunatic. I haven't seen the particular post that you're referring to. I will speak more generally. I have seen posts, plural, over the last several months, which I have found to be collectively unhinged. I've also found them to be, what would be the right word here? I have found them to be disappointing and disheartening, and also found them to be I have come to the conclusion at this point that Nick Rekieta is unreliable. He is simply unreliable. And so I don't at this point trust literally anything he has to say. So I don't even read it anymore, because it wouldn't matter to me what he said, because I don't have any trust in it. I don't have any confidence in it. So it wouldn't matter to me what he said at this point. It'll be really interesting to see, of course, in very soon, because I believe his sentencing is on the 24th, I think. So it's on 2 weeks from Friday. So we're going to find out real fast, you know, what his sentencing is going to be and what he's pleading to. And I've heard things in terms of the numbers, and then what I'm hearing doesn't even really make sense. So it'll be interesting to see what happens there. Did Nick plead out? He is pleading out. He's having a plea conference on the 24th. At which time I imagine that they will impose sentencing immediately, because it would be part of the plea. So I'm just assuming, yeah, there's a plea conference on the 24th, at which time he's supposed to enter a plea, and presumably there will be an immediate sentencing there too. So, yeah. Has the U.S. Supreme Court get involved? Well, we sort of discussed that. The U.S. Supreme Court gets involved on a supervisory appeal. And so you would have to have some sort of proceeding to appeal from. So the best way to get the U.S. Supreme Court involved would be, first of all, to get a decision from the district court, even a denial. Like if you filed a TRO, if you can get the district court to rule on the TRO, which is technically an injunction, then you could technically try to appeal that to the U.S. Supreme Court. So that would be my first thought. Temporary restraining order is a TRO. So my thought here is I would file in district court on a temporary restraining order, getting an injunction on a writ of prohibition. That's my immediate thought. And ask them to prevent the court from moving forward. And then I could try to appeal that on an emergency basis to the U.S. Supreme Court on a writ of certiorari. And so, yeah. Who is Circuit Justice? Who is Circuit Justice for the Second Circuit? Sonia Sotomayor. No, yeah, that's great. So yeah, I asked Sonia Sotomayor for emergency help. I'm not imagining that's going to go great, but those are my choices. I think they just want I just think they want the sentence. They want the sentencing so they can say, like, he's a convicted felon. Incidentally, by the way, it's meaningless as far as the presidency is concerned. I figure I should mention this. It's irrelevant as far as the presidency is concerned. Like, it doesn't matter. It's like, okay, can you get a security clearance if you're a felon? Well, I imagine it's difficult to get a security clearance as a felon, typically. I don't know that it's never happened, but it's probably difficult to get a security clearance as a felon. However, it just doesn't matter with the president, because the president is the original classifying authority under every law that matters. So he doesn't need a security clearance. He is the security clearance. He doesn't go. They don't go through a background check on the president. He's the original classifying authority. He's the one who makes things classified and unclassified. It's like he doesn't need a background check. He's the president, right? So it's like, well, it just doesn't matter in terms of the presidency. It doesn't inhibit him in any way. It doesn't prevent him from doing anything. I suppose another country could prevent him from visiting because he's a felon, but they could have done that anyway. Because that's just the recognition of states, right? So it's like, does it bar the president from visiting another country? Only if the other country wants it to be, and they could have done that anyway. They could have prevented the president of the United States from visiting anyway, because it's within their sovereign right. So it just doesn't matter. It just doesn't matter. It's just a thing that they can say that, oh, he's a convicted felon, and look, a convicted felon is in office. I'm like, well, okay. If it makes you feel better, I guess. And then, of course, someday someone is going to vacate the sentence. I imagine. I don't know who it's going to be. It might be the U.S. Supreme Court someday is going to vacate the sentence, and then everyone's going to get pissed again because they'll look at the courts and they're being, they're being political and they're being biased and whatever. So, yeah. Diplomatic immunity only prevents you from being charged with crimes when you're there, but it doesn't force the other country to host you. The diplomatic immunity does not prevent you from being declared persona non grata, which is a legal concept in diplomatic law, right? It's like, yeah, you have diplomatic immunity, but the host country doesn't have to recognize your diplomat. The host country doesn't have to recognize your diplomat. They can kick your diplomat out. They can kick the entire embassy out, right? Because the power to recognize other countries and other states and other representatives is within the host country's right as well. So it's like, he doesn't have diplomatic immunity. Diplomatic immunity does not prevent him from being excluded from another country. Another country can just declare him persona non grata, and then he can't go, and he doesn't have diplomatic immunity. Trump will pardon himself. Trump can't pardon himself because these are state level offenses. There's nothing to do there. He can't pardon himself out from a state level offense. So that doesn't work. Does New York have fine-only penalties for felonies? Yes. Especially like low-level felonies for first-time offenders? Sure. Which is pretty typical of most state law. Like globally speaking, like low-level felonies for a first-time offender, like, no time. Yeah, that's not like unusual. That part's not particularly unusual. What else can I answer for you? Isn't this a case where no actual crime was found? Depends on who you ask. I mean, obviously the jury convicted of what is a bit of a question mark. Whether or not the entire legal theory is sound is a bit of a question mark. There were discrepancies in the books. If you mean that there were no victims, then there were no victims, right? There was no one who was a victim of the bookkeeping manipulations. No one testified that like that hurt them in any way. So if you're saying like there were no victims, then okay, that's true. The only victim is arguably the state because there's corruption in the books. But so that's what there is. But then again, like the corruption in the books by itself is a misdemeanor, the statute of limitations of which has long since expired. So in order to get past that problem, you have to somehow bootstrap it into a felony. And the way they bootstrap it into a felony is deeply questionable. Plus, they didn't require the jury to agree on how they were bootstrapping into a felony. They came to the jury with 3 different theories of the crime and said, okay, just pick one. And you don't even have to agree amongst yourself which one. So there's some question marks over this case in my mind legally for any number of reasons. Plus also there's a selective prosecution problem that's lurking behind the entire thing because they certainly seem to go out of their way to prosecute Trump. Plus you have quotes from a lot of people saying we're going to go out of our way to prosecute Trump. So there's a selective prosecution problem by targeting Trump in a way that they wouldn't target anyone else. for this kind of offense. So the whole thing is legally questionable. The whole thing is legally questionable. They didn't change the statute of limitations, and you can't do that in a criminal case. Yeah, they didn't change the statute of limitations. You can change the statute of limitations civilly. You can't do it criminally. You can't change the statute of limitations in a criminal offense. So they didn't change the statute of limitations. They simply found a crime to which the statute of limitations had not expired. And then they bootstrapped themselves into that crime in a very questionable way. So, yeah, that's, yeah. Yeah, I mean, when it comes to civil law, you've seen a lot of extending the statute of limitations for victims in civil law, but you can't do that criminally. Yeah, you can't extend the statute of limitations criminally. So, yeah. They extended it because of COVID. The statute of limitations? They extended because of COVID? I would need to see a case that speaks to that issue. That they extended the statute of limitations because of COVID. Although I could see potentially like there is some like case law dealing with basically like if the courts are not functioning, like if they're completely shut down. So there might be some like, but that's like not, I mean, everything has asterisks in it in law. You should know that. But I'd have to like really read very carefully anything dealing with like actual extension of the statute of limitations because of COVID. But then it would just be because of basically like some sort of manifest necessity kind of thing. And I'd have to read that very carefully though. But I suppose there might be some hypothetical possibility. There's a question? Okay, let me get to that. Where's my Discord? As the clock governing them being stopped? Yeah, maybe. Maybe. Why is there a law talk about some executive orders that can't be stricken by incoming presidents? The no drilling for oil. Well, because the statute in question allows the president to designate basically the short answer to your question is the statute in question allows the president to designate protected lands. But the statute doesn't give the authority of the president to undesignate them. That is the thing, right? So it's the president is designating protected lands, and the next president can't simply undesignate it because it's in the statute or not, as the case may be. That's why. So the president can, but that's just what the statute says. So that's why. Yeah. The statute of limitations was told in New York by executive order due to COVID, and there are numerous appellate division decisions interpreting and endorsing the same. Fair enough. So some sort of manifest necessity thing. So yeah. So it's not that the statute of limitations is being extended. It's that the statute of limitations is being told, which is not quite the same thing. It's like, yeah. So it's like, that hyper precise thing, right? It's hyper precise. Yeah. So it's not the statute of limitations is being extended. The statute of limitations is being told. So that concept makes a little bit more sense to me. And you can have tolling, which is just stopping the clock. You can have tolling in civil law too for statutes of limitations. So that concept is not like unknown to me. So yeah, so they told the statute of limitations because of COVID, basically on a manifest necessity kind of thing. It's like, okay, that makes a little bit more sense. That makes a little bit more sense. And then that's where I'd have to like really deep dive into the case law. You know what I'd like to look into some point? Um, you know what I'd really like to look into? And someone can help me out on this, maybe in Discord or otherwise. But I was watching like a clip from like Tim Pool talking to some leftist asshole, nobody or whatever, right? And Tim Pool referred to a guy relating to January 6th who's been held for 3 years without charges. And that doesn't seem possible. I'm not saying he's lying. It's just like it doesn't seem possible. That you're held for 3 years without any charge? That doesn't seem possible. So I'd like to know who he's talking about, and I'd like to be able to look a little bit into that and try to figure out a little bit what's going on. So if you happen to know who Tim Pool was talking about, someone being held for 3 years relating to Jan 6 without charges, I'd like to know who we're talking about, and so I can look into it a little bit. Yeah, I mean, it seems like a habeas. It seems like a fairly easy habeas. Yeah. So that seems like odd as hell. By the way, do you like my hat? I got it restraightened because people were saying it was crooked. Is my hat all straight now? I got the brim restraightened so that it wasn't so bad. So is my hat glorious? Is it glory? Is it back to its glory? Yeah. I don't think they can hold anyone for 3 years without charges either, too. That sounds wrong. Yeah, that sounds wrong. But that's what Tim Pool seemed to be saying, if I understood him correctly. Tim Pool said that there's a guy they've held for 3 years without charge. I'm like, that doesn't seem possible. When they put Richard Allen in solitary confinement, yeah, I mean, that's deeply questionable. That's incredibly questionable. When they held Richard Allen in prison pending trial, that's weird. It's not, I don't think it's completely unheard of, but it's really unusual to put someone in prison pending trial. That's really weird. That's usually they're in jail. They'll sometimes, if they're currently a prisoner, they'll be held in prison pending trial. But for a person who's not currently a prisoner to be held in prison pending trial, that's really weird. And then for him to be held in solitary, that's also really weird. Yeah, that Richard Allen thing is really, really weird. That's really odd. You were thinking the hat was new? Yeah, well, I just got it reshaped. I just took it to the hat store and got it reshaped with a little steam. All right, well, maybe someone will tell me exactly what case Tim Pool is talking about, and maybe we'll look into it and try to figure out what's going on. Because if someone's been held for 3 years without charge, it's like, yeah, that seems odd. That seems really odd. It would even be odd if they were held 3 years without like any court without a trial. That would also be pretty weird. So I'd want to know exactly what they're talking about, exactly what's going on, and see whether or not it makes sense or doesn't make sense. Maybe it does make sense. Maybe the delays are due to the defense. Maybe a lot of things. I don't know, but it's like I'd like to look into it and try to figure out what's going on. Jake Lang held over 1,300 days with no trial or bail, not without charge. Okay. Yeah, that makes a little bit more sense. 1,300 days without trial is a long time without trial, though. The style of hat is called Gus. That's the style of hat. It's called Gus, and I like it too. It's not a top hat. It's not a bowler hat. It's a Gus hat. Or bail hearing. That seems odd too. Did any of the Jan 6 ask for speedy trial and denied? I'm not aware of that. I don't know. Let's see what we can sort of try to figure out from at least some articles. Let's just read some articles and see if we can try to figure out what's going on with this Jake Lang thing. Well, he's been denied bond, which isn't the same thing as a no bond hearing. So yeah, it's like let's try to be precise about what's going on, right? Let's try to be precise. Let's take a look at this thing here and try to figure out what's going on. All right. Capitol rioter starts militia from inside prison. Exciting, according to Newsweek. Edward Jake Lang, who's been in jail for nearly 40 months awaiting trial on multiple counts of assaulting law enforcement officers, civil disorder, and obstruction of official proceeding during January 6th, has taken to social media to organize a militia. Ooh, spicy from Newsweek. Lang, who's a well-known internet personality and self-described January 6th political prisoner, was arrested 10 days after the riot and pled not guilty. He's mainly been held in the nation capital, but in March was transferred to a detention center in Brooklyn. He's scheduled to stand trial in September. While in prison, Lang had taken to social media to organize like-minded supporters, most of whom promote conspiracy theories. Well, this article is neutrally written. That the 2020 presidential election was stolen and Donald Trump won despite no evidence of widespread voter fraud. Also, by the way, while I'm thinking about it, if anyone happens to have a copy of what I assume is the Court of Appeals for the Armed Forces decision that says that the plea deals relating to Guantanamo can't be rescinded by the Secretary of Defense, I'd like to hear that. So I'd like to read that. So for those of you who don't know, there's like 2 or 3 different people in Guantanamo. They've been offered a plea deal to plead guilty. Basically, they get life in prison, or they get a guarantee of no death penalty, but they get life in prison, which sounds like which means they're going to ADX, which, sounds like shit to me, but it sounds like a shit deal to me. But a lot of the families relating to September 11th are not happy with the deal. Anyways, the Secretary of Defense, I believe, tried to rescind the deal. And the Court of Appeals, I assume the Court of Appeals for the Armed Forces issued a decision saying the Secretary cannot withdraw the deal. And I'd really like to read the decision. So if anyone happens to be able to find a copy of that, that would be really helpful, so that we can read why the Secretary of Defense can't withdraw the deal. Because it deals with military law. Military law is always interesting. Pressing back to Lang, who is not being tried in a military proceeding for the moment. In early June, Lang posted on X calling to join a new national constitutional militia, North American Patriot and Liberty Militia. Well, I'm starting to figure out why he's not being given bail. The group's mission statement reads, "We the people, to uphold the Constitution, will protect America from any enemy, foreign and domestic." NAPLAM says Jesus Christ is our commander-in-chief and calls itself not a fringe or extremist group, but instead we represent the people, the core of America. Okay. Since then, NAPLAM has started 50 state-specific militia Telegram channels. According to Wired, Lang claims that the group chats have over 20,000 members. However, his number has been disputed. The group, chaired by Lang, features QAnon promoters as a vice chair, leader of Cowboys for Trump. Exciting. And Stu Peters, who the Anti-Defamation League, who is a shit group, and I hate the ADL. They're a bunch of fucktards. So the ADL can say whatever they want. They can screw themselves because they suck ass. Regarding the malicious formation, origin of formation, Lang told Wire, "There's a tyrannical wave that has hit America we've never seen before. And so it's time that people get organized in case they can escalate to something that basically puts our very life in danger." Yeah, I'm beginning to understand why he might have been denied bail. I'm beginning to see some clues. What else do we got? Man who spent 4 years in jail on Capitol riot charge gets trial delayed as he angles for pardon. A New York man who spent nearly 4 years behind bars on federal charges tied to January 6th, go away thing, got his trial pushed back after arguing Donald Trump could pardon him when he takes office. Jake Lang, who's the longest-serving Jan 6 defendant, waived trial after he allegedly swung a baseball bat at law enforcement outside the Capitol during the rampage. Not a legal win when a judge delayed his trial over objection by federal prosecutors. Lang, helping to represent himself, claimed in legal papers that Trump's win over Kamala Harris indicated a seismic shift in federal policy. Yeah. The Sullivan County Local added there's a high likelihood of presidential pardon or dismissal. That part, I think, is very likely true. But, that's neither here nor there. The president can pardon anyone he wants for any reason he wants. So that's really separate and apart from the legal process, because a pardon is a political act, right? So whether or not President Trump will pardon him or not really has not much to do with any legal proceedings. I mean, because it's a political act. It's neither just nor efficient to subject the defendant's chauffeur trial in front of a prejudiced jury pool under a prosecution marred by political bias, requesting a date after January 20th. He and his lawyer also cited blah, blah, blah. His trial was scheduled for December 2nd. Lang was initially busted on January 16, 2021 for his alleged role in the riot after he posted an image of the mob on social media with the words, "This is me," with a pointing emoji superimposed on it. Yeah, that kind of will do it. Please stop snitching on yourself. So the guy posted an image of the crowd of January 6th, and then he put an emoji on it with an arrow pointing at him, says, "This is me." Yeah. I think the government can make their prima facie case. I think the government can make their prima facie case. Do we need to have a Capitol Riot edition? It's been a long time since we did a Capitol Riot series. Do we need to do a Capitol Riot series on this guy? It'll be number like 56 in the series or something. It's been a hot minute since we've done one. Do number 56 in our ongoing series of the Capitol Riot series. This guy is super duper guilty. Okay, incredible. Since his arrest, he's been detained in D.C. awaiting trial. The U.S. District Court reluctantly put off Lang's trial, not just based on the possible pardon, but other issues with the timing of the court. Other arguments the defense offered in a bid to delay included other January 6th cases, cinching delays, and defense lawyers recovering from surgery. Prosecutors argued Lang's claim he could be pardoned is purely speculative and doesn't warrant a delay. Uh-huh. Is that him? With few exceptions, effort to continue proceedings arising from the events of January 6th based on hopes of a pardon have failed. Trump addressed his potential pardons, saying, "I would pardon a large portion of them." Okay. That's good. Okay, no, don't need that. All right. Lang, a former resident of Knaresborough, was arrested after the attack when he lived in New York. He's been in prison ever since. His profile says Jake Lang, Jan 6 political prisoner for 1,040 days without trial. Well, it seems like some of that delay might be due to Mr. Lang himself, obviously of which he can't complain, right? If he had been denied his right to a speedy trial, okay, we'd be talking. But if he's been asking for delays, which it seems like partially he's been asking for, it's like you can't. Some of that seems like it might be Mr. Lang. So, and also it doesn't seem like he's a political prisoner, not within any sense that I understand the words. It seems like the government has a prima facie case he broke the law. He is accused of wielding deadly weapons, including a bat and shield. He's also charged with obstruction. All right, we need to have an emergency. We need to have an emergency edition of this. So here's what we're going to do. We are going to do a new stream, and we are going to start over again, and we're going to do Jake Lang edition. That is what we're doing. I've decided. So some of you guys get to hear this twice. I apologize, except not really, because I'm doing it anyway. Jan 6 cases. And we're going to look up Mr. Lang's case. And we're going to discuss Mr. Lang's case and the case there too. So let's see. Lang. Lang, Edward Jacob of New York. Civil disorder, assaulting, resisting, impeding officers. Assaulting, resisting, or impeding officers using a dangerous weapon. Obstruction, aiding and abetting, disorderly conduct. Disorderly conduct, act of physical violence. Yeah. I think Mr. Lang has been bad. All right, so what number is this in my ongoing series? That's what I need to find out. It has been a hot minute. The ruling in the military appeals court. What? You give it to me on Discord? Yeah, you give it to me in Discord if you have it. That'd be worth cool. If you have a copy of the decision, I'd appreciate it. Sounds like typical overcharging. I don't know. We're going to find out, I guess, based on the evidence the DOJ has. The DOJ's cases are usually pretty good. I mean, we've of the 50 or so that we did, we only found one of the 50 or so where I thought, the DOJ might not have this one. The DOJ tends to. I mean, there's a reason that they have a 99% success rate, right? It's like the DOJ tends to be pretty small c conservative in bringing charges. They tend to only bring it when they've got it. So where is my Capitol Riot series? It has been a long moment since we've actually done one of these. Oh, okay, 58 in the series. This is number 59 in the Sometimes series. I think it is. Let's see. $49. So this will be 50? No. It's more than that. This will be number 58 in the ongoing series. YouTube does block links. Yes, YouTube does block links. So you have to send it to me on Discord or some other way. So let's do number 58 in our Capitol Riot series. All right, guys, I will see you in a minute. We're going to do this thing. This is going to be exciting. So watch for a new stream. I'll see you in just a second. All right, bye-bye for now.